Balance council, how much time would you like for a bubble, ma'am?
3 minutes, Your Honor. Thank
Okay.
you.
I definitely know how to do that.
Thank you. May it please the court. Kara Link on behalf of the appellant and with my co-counsel Carlos Diaz Argelis, it's our privilege to represent Senior Judge Thorpe. This appeal presents this court with an opportunity to decide a split among the appellate courts on Florida's long arm personal jurisdiction statute 48.193. So as a threshold issue, this court can decide, as the first DCA did in Dean, that if the act occurs outside of Florida, but the injury occurs here, then personal jurisdiction vests in Florida. And that's specifically under the Dean case. And before we get to Venetian salami and the two-part test, I want to add that there is another way that this court can reverse. If you don't agree with Dean, the other subsection of the statute that we argued below and have pled in the Second Amendment complaint is 48.193.186 A and B, which specifically addresses causing injury to persons within the state arising out of an act or omission by the defendant outside of the state.
Counsel, I thought that was an interesting argument.
Mhm.
In parsing the words of subsection 186, it says, at about the time of plaintiff's injury, it says causing injury or injury to persons or property within the state arising out of an act or omission by the defendant outside the state, if, quote, at or about the time of injury, at the time of injury, either one of the two conditions was met.
Right,
Okay, and the conditions you're relying on are, I think, both of them.
both
Okay.
correct. That's
And
correct.
so the way I read that is whether it's the service activities under sub A
Mhm.
or the materials processed under materials,
B,
products, things processed, service manufactured under sub B. The way I read that is that would have had to occur at least around the time that the plaintiff's injury occurred. Okay, so it says at about the time of the plaintiff's injury, either one of these two things happened. Either the defendant was engaged in the service activities, or B, products, materials, or things processed, service manufactured by the defendant were used in the state.
right.
So there's a time connection that's required there under the statute between the activity that occurred and the time of the plaintiff's injury. What paragraph of your complaint connected the time of those activities to the time of plaintiff's injury?
Thank you. That's an interesting question, and I don't believe it was raised below or in the answer brief, but the paragraph, Your Honor, that answers your question is 50. Paragraph 50, we pled that while the doctors were working for Sloan Kettering, they reviewed her medical history, performed the tests, collected the slides, rendered written reports and analyses containing their diagnoses and recommendations, which were flawed. That was the medical negligence, which were used in Florida during the treatment of Jennifer Palmer. So while those,
Okay, so it says they were used during her treatment.
right, treatment,
Okay.
which,
Okay, but it says at the time of her injury.
right,
That's what the statute says. The
Well-
statute says it has to be at the time of
of
injury.
injury.
So
Well,
your position is the injury came after the treatment.
her injury is occurring because it's metastatic cancer that was missed. It was
Okay, hold
missed
on. So I
by,
want to stick with my question though.
yes,
That paragraph didn't speak to the time of her injury.
of her
It
injury.
speaks to the time they used the reports.
Then,
Which paragraph of your complaint connected, because that's what it says in the statute.
right,
At
understood,
about the time of her injury,
understood.
what paragraph of your complaint connected those activities to the time of the plaintiff's injury of the decedent's industry?
I'm looking at the jurisdictional allegations, Your Honor, that are contained within 33 through 57. We don't have a specific date of injury because I think metastatic cancer is an evolving injury, right? There's a,
But you gotta allege something.
oh, we
I'm gonna
did,
ask
we
again.
did, that are
What?
in,
This is attempt number 3.
Fif-
What paragraph of your complaint connects the time of the injury to the time of the use of the reports?
we don't have a date for her injury. We have a date that the injuries were preventable in paragraph 57. We have
So
a date.
the complaint does not connect the time of the injury to the time of the use of reports. Is that correct?
I don't believe it does. As I'm reading those jurisdictional allegations, they do not have a date of injury that Your Honor is looking for.
Do they have any, it says about the time of the
About
injury.
the
Do they
time.
have a time frame? Anything that would satisfy that standard about the time of the injury?
I think,
I don't think the statute requires you to give a date and time, but
I
it does
don't
require
either.
you to make some cuts,
I-
some
I would agree.
temporal connection.
Right, I agree. I don't think that it requires a specific date.
Right.
Um,
Is there any, does the temporal connection occur anywhere in your complaint?
I'd have to pull the rest of the complaint. I have the jurisdictional allegations right here.
Okay.
But I'm wondering that perhaps one of the specific counts have a date. I know that the injury occurs in Florida and there's no dispute of that. I know that she returned to Florida after her first operation in 2014. She returned to Sloan Kettering in 2015 for the second. She returned back to Florida in 26 or after that 2015
But you
surgery.
can't cite a temporal connection the complaint makes between her injury and the. use of
There might be
materials.
one. I'll have to, I'll look when I sit back down, Your Honor, but that argument wasn't raised below. I think it is,
Okay.
um,
The other
it-
question I had about that
Mhm.
was these, and I think it was pointed out in some of the briefing that these were subsection 6 is, or sub 1A6 is, seems to be connected to manufacturing, product liability and solicitation.
right,
It's not limited to that, but it seems to be what it was targeted at that. But we do have to, so the language might be broader, but we're still bound by it. And the language it uses for sub 6B is products, materials, or things processed, serviced, or manufactured.
right,
And what you're saying is a medical report that the doctor wrote was ultimately used by another doctor.
correct.
Does a
Materials.
medical report written by a doctor constitute something that was processed, serviced, or manufactured?
By the defendant anywhere that's being used in the state
Correct.
for its use in its common ordinary course
Yeah,
of
is
use.
when anyone writes a
Yes.
report, do they say I manufactured the report?
Yes, and you have to support that, the Thomas Jefferson case, which found personal jurisdiction under that precise subsection based upon reports.
I noticed,
And-
but I'll be honest, so that wasn't the
Yeah.
Thomas Jefferson case, that was the concurrence in the Thomas Jefferson case, right?
No, the Thomas Jefferson case and the Dean case both found personal jurisdiction under that particular subsection. Judge Farmer in Thomas Jefferson wrote a dissent and he said it was a concurrence and a dissent. He concurred and he said, I agree with you all. This was not we didn't commit a tortious act within the state of Florida. I disagree with you all on this subsection that you and I are discussing, but there was personal
agree with that.
jurisdiction by the majority there.
Here's my point about that.
Mhm.
The materials that were processed or serviced or manufactured by the defendant in the Thomas Jefferson case were
Yes.
blood.
Right?
And
And
the
reports.
blood was not used in the states. The reports were used in the
Correct.
states.
That's right.
So I'll be honest, the case didn't make a lot of sense to me because the thing the defendant processed was blood.
Right.
The defendant didn't process a report. The defendant created a report that was later used. But the statute says that the products, materials, or things processed, serviced, or manufactured by the defendant must be used in the state.
Mhm.
The blood was not processed or used in the state. It
The
was
report,
processed in Pennsylvania.
correct.
the
The
report
reports
was.
were, that's right.
So I'll be honest, that the opinion just seems wrong to me.
Okay.
because The
All right.
thing that was processed was not
Mhm.
used in the state of Florida there.
Right. Well, it
So-
was the reports and they don't identify which of those disjunctive items are triggered by reports. It could have been products, materials, or things. Things is pretty broad.
But was the report?
Things could be a report.
I agree, I think it's a good report, but was was the report processed, serviced, or manufactured?
Absolutely. Yes.
So
It was
have you ever
created.
heard when someone refer to a doctor writing a medical report?
Yes,
Have you ever referred to them, say, well, the doctor, talking about someone who wrote the
Process.
report,
right,
saying
right.
the doctor processed a report?
The statute could have something a little bit more precise for,
Is it
What
not just
we're
not precise, but
discussing.
completely different?
I'm sorry?
Is it not just not precise, but completely different?
Well,
You ever, as a user of the English language, hear somebody say.
I processed
a report,
or
meaning
I
they wrote the
processed an
report.
appellate brief. I processed an
Have
appellate
you
brief.
ever used the word I process an appellate brief referring to your authorship of the brief?
Manufactured an appellate brief? No, I probably haven't, Your Honor.
Okay,
But-
have you ever heard any person as a user of the English language used the words processed, serviced, or manufactured to mean wrote a document?
Processed a report. I could see that being used. I could absolutely see processed a report
For the
being,
person who
wrote
wrote the
a
report as an
report,
original
yes.
matter?
I could see process falling in that category. And certainly Thomas Jefferson in the majority of that court, they found that to meet that definition, as well as the Dean Court. The first TCA and Dean, not only did what I'm asking this court to do, which is to find that Florida's personal jurisdiction long arm statute is triggered when the injury occurs in Florida. They checked the box and they said, that's what we're going to
Have so
find.
much more than we have in this case. How do we know that this case is meeting the threshold that they had in Dean? I mean, it seems to me that in Dean, the doctor that was out of state,
Mhm.
it's Alabama, or
Yes,
the doctor that was out of state was very much involved in that patient's treatment. The
Right.
surgery took place in Florida. The reports are, well, I could just look at my notes here.
He owned property here.
So for that,
yes.
but even on the first portion of it,
So,
he's licensed there.
mhm.
Yeah, the property going to
Pay
that second element.
taxes, all of those, yes.
So wasn't he very much more involved in, and I'm asking because I'm trying to understand this threshold, although I recognize the fact that the DCA seemed to be in conflict about this, but there
Right.
seemed to be so much more in Dean. He's very much involved in that surgery, talking to these people. Were the doctors in this case truly treating her in New York, but then she needed those reports so that she could go and receive treatment in Florida?
So two things.
Yeah.
First, to answer your question about the Dean case, all of those wonderful facts go to prong two of the Venetian salami case. There's sufficient minimum contacts. And when the court writes that, they say, oh, this prong two is easy. I think they use the word easy in the opinion because he owned property, paid taxes. And yes, those sufficient minimum contacts are, there are a plethora of them. The Florida license is another fact. So Dean had a lot more in it, Your Honor. That all goes to sufficient minimum contacts. I'm not even there yet. I'm on prong one of Venetian salami. So let me meet that test on prong one. To answer your question about the doctors in this case, they were just as much involved as Dr. O and Dean. Make no mistake. Not only is it clear in the Second Amendment complaint allegations, the personal jurisdiction allegations that we plead, that they were aware she was coming back to Florida. They were
But
aware
isn't
that,
awareness, and I'm sorry to interrupt you, Council, but isn't that awareness? Because I want to focus, I think what you said at the outset of this is important. I'm not
Mhm.
trying to focus on due process. And
Okay.
minimum context. I'm trying to focus on long arm. But if I look at Dean, says the unnecessary surgery was performed in Fort Walton Beach. Her injuries resulting from the misdiagnosis occurred in Florida. I think that you could latch on to that, right?
Mhm,
Um,
correct.
but Dr. O's phone calls and reports directed to Dr. Johns in Florida were for the purpose of treating Mrs. Dean in Florida.
That's my paragraph 50, Your Honor. That's my paragraph 50. 50 says that the two doctors working for Sloan Kettering reviewed her medical history, performed tests, collected slides, rendered, there's another word, rendered, written reports and analyses containing their diagnoses and recommendations, which were used in Florida during the ordinary course of treatment of Jennifer Palmer. And paragraph 54, those are my two best paragraphs, 50 and 54. 54, while working for Sloan Kettering, Dr. Yoon contacted Palmer's doctors here about his diagnoses and his professional opinion of her conduct. He missed it. So he's transmitting and communicating with these doctors a faulty diagnosis. He has absolutely missed the fact that she has cancer. She has metastatic tumors that if his radiologist had read it correctly, if he had read it correctly,
I agree.
if they had.
54 says they contacted the doctors here. Does anything in the complaint allege that negligence occurred on that phone call?
Well, I think that is part and parcel of the allegations that you
It says
go.
they contacted the doctors in Florida about their diagnosis and.
Yes, correct.
So they're, the act that took place in Florida, and I agree, when it says communications into Florida can
Right.
constitute a tort in Florida. But the act that the communication sent into Florida has to be the tortious act. The phone call, does any of the plate say on this phone call, the doctor committed malpractice or was negligent? in some way?
I may have been unclear. The tortious acts don't have to occur in Florida for us to adopt Dean. The tortious acts can occur in New York, and we have pled those tortious acts of misdiagnosis, of not
But
ordering the
you said
PET
that you
scan.
emphasized by the phone call that it happened in Florida.
Right, that
seems to be
did.
what you-
Yes, correct. I was
Okay.
trying to meet Judge Brownlee's question about how do you have the same facts of Dean? And the facts that I have that match up with Dean are the contact. If there was no phone call, no communications, and that's the Florida Supreme Court Went case, I have acts that occur here in Florida, communications. If I don't have that, I have issues. I have direct contact with the doctors here in Florida.
Okay, but if you're
Communications
requiring, so
Yes.
if you're requiring if you're relying on the phone calls into
Mhm.
Florida, that would mean the phone calls themselves have to satisfy the long arm statute. So that would, the phone calls would have to be the tortious act. Is there something in the complaint somewhere in the complaint where you allege malpractice was committed on the phone call?
In Dean versus Jones, the tortious act doesn't have to occur here in Florida. That's not, the Dean versus Jones is everything else can
Because I get it.
occur somewhere else.
There's
It's just
two
the
issues here.
Injury here.
There's two issues here where you seem to be jumping back and forth.
Okay,
There's the fact that acts occurring outside of Florida.
Right.
That cause injury in Florida. And I
Absolutely.
understand that's your primary argument.
yes, correct.
But in response to Judge Brownlee's question, you
I-
seem to be saying, I also have acts in Florida.
I do, and I wrote that in my brief. I
Okay,
do, I
okay.
absolutely do. Yes. So thank
Okay.
you for making
So
it
for that
clear.
second
I have
prong
two,
of the acts in Florida,
yes,
the acts in Florida must be the tortious act. So if you're going to say the phone call into Florida, that would mean the phone call would have to be tortious on its own.
Well-
Is there anything in your complaint where you say the phone call was tortious, that was negligent in some way?
in 54, it does not say the phone call was tortious. It says that he conveys or contacts her Florida doctors about his diagnosis. You read the entire complaint, you'll know his diagnoses are flawed. So what he's communicating is negligence. He's giving bad information to the doctors in Florida and his professional opinion based on everything that we have pled, including his diagnosis, his opinion, and all of the medical records and tests.
Susan Counsel, can you respond to the trial court's reasoning in its order that
Mhm.
your reasoning of sub 1A2 would render sub 1A6 meaningless because, sub 1A6 specifically addresses acts committed to someone outside of Florida, which we discussed. And it gives the two conditions, and it basically is targeted at solicitation and product liability.
Right,
If sub 1A2 renders anyone that causes injury in Florida by committing an act outside of Florida subject to personal jurisdiction here, that would totally encompass 1A6. Now, in your brief, you respond that reasoning is flawed because 1A6 is targeted specifically at product liability and actions claiming solicitation or advertisement.
Mhm.
But to me, that was kind of the point, right? The legislature wrote a specific provision about when to give jurisdiction over someone that commits an out-of-state act, and they only included product liability or solicitation in that provision. If they wanted to include other types of cases, they could have, they didn't. And bottom line, under your reading of sub 1A2, if that included any time an out-of-state act caused an injury in state, that would totally encompass 1A6, wouldn't it?
So there's a law review article, Florida Law Review article that I cite that very thoroughly discusses this very issue and the injury issue and whether you should broadly or narrowly interpret this statute with regard to the physical injury being completed here in Florida. And that article says, and it's important, 1A6 reserves to 1A2 all specific personal jurisdiction where the non-resident defendant does not engage in any business or does not perform services in Florida. So if this court were to find there is no business being engaged in, no professional services being performed here in Florida, then 1A2 captures the non-resident defendant who
But-
causes an injury here in Florida.
If 1A2 captures that.
Yes.
Wouldn't it also capture what's in 1A6?
Would it also capture
Yeah, if
1A6?
1A2 includes any time somebody out of state commits an out-of-state act that injures someone in Florida.
Would it also fall under 1A6?
Yeah, wouldn't
I
anything
think
that
there's a
fall,
possibility, Your Honor.
Yeah,
I think there's a
under your
possibility,
interpretation,
There's a
anything that
possibility.
satisfied 1A6 would also satisfy 1A2, correct?
possibly. I think it's a tight mesh
Can you tell
between
me-
the two.
Can you tell me any possible thing of
Mhm.
any kind under your reading of 1A2 that would satisfy 1A6, but not 1A2?
That would not satisfy 1A2, but
Correct.
would satisfy 1A6.
Is there any work 1A, under your reading of 1A2, is there any function left at all to 1A6?
I'm trying. I'm thinking about cars. I'm thinking about,
Alright,
I'm
yeah.
thinking about some other option that would
You're in
fall
your-
under.
you're into your rebuttal time?
I'm into my
So,
rebuttal time already. Well, I just want to make one
I'll
very,
address that in a rebuttal though.
okay, thank you so much. And I haven't had a chance to adopt or to address the sufficient and minimum context. But so it's unfair to my opposing counsel to not do that, to think that I have any lack of belief in them, but the this court knows that it's not fortuitous, random, or attenuated contacts within Florida, and that we pled the sufficient minimum contacts. They pursued collection efforts against my client here in Florida. They billed my client here in Florida. They contacted the Florida doctors here to talk about treatment. So there is no shock and awe or surprise that they would be hailed here into court in Florida. It was purposeful that they sought collections against my client. So I wanted to make that comment. And
Counselor,
also,
your time is up. I am going to give you 2 minutes for rebuttal because I
Oh,
know we ate into your time.
I'm into my 20. Thank
I'll
you.
give opposing counsel 2 minutes as well.
Thank you. Your Honor.
All right, counsel, you have an extra 2 minutes.
Thank you, Your Honor. May it please the court. Christopher Brown on behalf of the appellees, Memorial Sloan Kettering Cancer Center, Dr. Sam Yoon and Dr. Sinchan Huang. So at its core, this is a question of what is the breadth of Florida's long-arm jurisdiction? And Judge Brownlee, to kind of address your concerns with the Dean v. Johns case, I know that was heavily relied on by appellant's counsel. The facts in that case are very different than what happened between Jennifer Palmer, Sloan Kettering, and my clients. In Dean v. Johns, you had an Alabama doctor who was treating a Florida resident in Alabama. That Florida resident then received a surgery that was recommended by the Alabama doctor in Florida, had some significant neurological damage. And then the big difference here is that the Florida patient went back to the Alabama doctor. So there was almost a collaborative care going on. And that's why the court.
There was a lot more in Dean. I mean, in Dean, it seems like the doctor was actively participating in Florida care, but that doesn't seem like what the first relied on, right? The first DCA did say we'll go in time and place of injury, right?
The first DCA did say that.
It
And
seems to me you've got to argue Dean was wrong because Dean might have been distinguishable. I mean, the first might have been able to decide it differently, but they didn't. Like they looked at all those facts and they didn't say, we find this to have been essentially part and parcel of care in Florida. They said, we're going time of injury, or place of injury, didn't they?
they did say that in Dean in the first DCA, but then you have subsequent case law from the third DCA, the second DCA, even the fifth DCA. And
I know there's a DCA split. My point is, it seems to me when the first DCA says, here's our holding, we kind of got to take them at their word. And if you disagree with the holding, you got to just argue that it's wrong, as opposed to say, well, they could have made the holding on a different basis. There were other facts they could have relied on. They did say all those facts, but then they said, we're going place of injury, didn't they?
They did, Your Honor. And, I would urge the court to follow the later holdings, the split in jurisdictions in which they determined that the statute expressly states that the tortious act has to be committed in the state of Florida. And
Can an act ever be tortious that doesn't result in damages?
well, what the later courts have said is that it doesn't necessarily matter where the damages are. It's where the tortious act is committed.
I know what I'm saying is an act is not tortious without damages. How can you separate the two? The damages are what makes the act. A tortious act is an act that causes injury through the negligence or intentional misconduct of another, right?
Correct.
If there's no injury, there's no tort. If there's
But-
no tort, there's no tortious act, right?
But this is the prime example, this case and these facts, because you have doctors who are allegedly negligently treating Ms. Palmer in the state of New York. That's the tortious act. The tortious act is their negligent treatment in the state of New
Let
York.
me ask you this, if they had done the same acts, whether or not those acts were negligent, I'm not saying one way or the other, but they had just done the exact same acts at whatever level of care that was, good or bad, and she just got better. Okay, she was not damaged. She woke up, her cancer was gone. She had no damage of any kind. Would those acts still have been tortious?
You wouldn't have a negligence claim, but because I understand what your honor is saying. I understand that negligence or damages are a key element to a negligence claim. But
they're
it
not
matters
just-
when that.
They're
the
not
damage
just key elements of the claim, they're what make the act tortious, aren't they? An act that does not cause damages, as a matter of law, is not a tortious act, correct?
That's correct, Your Honor. But I don't think that you've got an individual who's traveling from the state of Florida to the state of New York for treatment. It's that treatment that is allegedly negligent. That treatment that she received.
So assume it was assume it was negligent. Was it tortious at the time the doctor committed the act, or did it become torturous when the damages were suffered?
I would argue it's tortious at the time they committed the act. The damages follow at a later date.
How? Why is it a tortious act isn't torturous without damages, is it?
But what your Honor suggesting is that the negligence claim or the damages element to the negligence claim extends in perpetuity. It just, you know,
I'm saying the tort is completed. And this is how we look at, like, in other contexts, how our tort is felt, right? A tort is completed where the last element occurs, right, which is damages. Now, the distinction here, and some of the cases talk about this, is they didn't say commit a tort, they say commit a tortious act. And that's the basis to, I forget which case it was, drew out that distinction and said that the legislature could have said commit a tort. And that would make sense because we treat a tort as where the last element occurs.
Mhm.
But we don't do that here because the legislature said tortious act, not tort. And my point to kind of dig into that a little bit is, how can it be a tortious act without a completed tort?
well, I think
Is
it's,
that logic circular?
yeah, well, I mean, if you look at a negligence claim, you've got duty, breach, causation, damages. I think the breach is the act. Well, they had a duty and the breach is the act.
Is it a tortious act?
That's a question for the legislature. I honestly think that, you know, they wouldn't have said act. And I think act encompasses that breach element of a negligence claim.
Which is
So
what's borne out in the Thomas Jefferson case. Is that right?
it
It's the
is,
distinction between the tort and the tortious act that's reflected in the statute.
it is. In the Thomas Jefferson case, the concurring opinion, I think, makes a statement that it's not really they state that the damage element in a given case might occur. It's the commission by the defendant of the act itself, setting into motion the various elements that combine to make a tort. So it's the act itself. It's that breach that occurred that ultimately is the question for this court for jurisdictional purposes.
I mean, if you're comparing it in a criminal setting, you would have someone on the border where a crime could be committed in one state, a stabbing, and the hospital that the urgent care is in Georgia. Let's say it happened right at the top, and they transport them to Georgia. If you're going with the completed murder is when the person dies. You're sitting there saying they're in Georgia. That doesn't seem to make sense that the act itself happened in Florida. And so I think that's what the other DCAs, not in the Dean case, but the other DCAs are saying it's where the actual action is happening rather than where the result of that accident. And I
Yeah,
know there's distinguishing between criminal and civil, but that's where I'm getting hung up a little bit on this issue of a completed tortious act is where you have the completed injury. Because ultimately, in this case, it seemed that the decedent ended up, she moved from where she was getting the care to this new state. What keeps anybody from saying, well, I'm going to move again, and I'm going to move again, and all of a sudden, whichever state has the best laws with respect to statute of limitations or anything else, you could ultimately make the claim that the cancer was getting worse at each place she went. And so, you know, that's one of the concerns I'm having.
yeah, and I think that's a public policy argument in that, you know, that clearly wasn't the intent of the legislature to allow this type of claim to pass from jurisdiction to jurisdiction, because, you know, ultimately, you know, the long arm jurisdiction is to protect the residents of Florida. And you've got an individual here who was traveling to New York. She wasn't receiving treatment from my clients in the state of Florida. We provided affidavits that are in the record that establish that the allegations in the Second Amendment complaint clearly established that almost everything that occurred in the state of New York. We've got a discussion about communications. And I heard Your Honor bring up the Wendt rule, Wendt v. Horowitz. But as you said, the communications, that only applies as a tortious act if the cause of action arises from those communications. And then there's later case law that states that really that has only been applied to slander actions, fraud actions, and other intentional torts. It hasn't been applied to general negligence claims. So I don't think that the communications can be used to establish a tortious act.
I thought that your brief said that the doctors in this case never consulted or made recommendations to Florida physicians.
So unfortunately, what's not in the record is the deposition of Dr. Yoon.
Okay.
And that was
It was not on the record, counsel. We don't even hear.
and that's, I don't want to address it, Your Honor. The only communication that I'm aware of is that there was the referral to the Florida physicians and that Dr. Yoon may have had some
Well,
limited contact.
So their complaint, is taken as true unless disputed by an affidavit, right?
Correct, Your Honor.
They allege in paragraph 54 that your clients did contact doctors in Florida to discuss their diagnosis and opinion, correct?
Yes, Your Honor.
And there's no affidavit in our record disputing that, correct?
That's correct, Your Honor.
We would have to take it as true.
Yes. But
How do you overcome that then, counsel?
I overcome that because if we're looking at the communications, they have nothing to do with the tortious act. There's nothing alleged in the Second Amendment complaint that the communications were negligent in some way. The records themselves, I think that was an issue that was brought up. But I'd point out that those records were created in the state of New York by Dr. Yoon and Dr. Huang for use in the state of New York. They were never intended to be transported or sent out of jurisdiction, but Ms. Palmer has a right to those records. And she has the right to request that those records be sent wherever she wants. And my clients can't oppose that right.
And in that way, is it distinguishable in your mind from Dean? Like, is that because it almost seems to me that in Dean, there's sort of this, they're working in tandem where the doctor in Alabama is working with the Florida physicians. I mean, do you think that that's a distinguishing piece as well?
I do, because the records in this case clearly were not intended to be used in Florida. There's no collaborative agreement there. There's no relationship between my clients and the doctors in Florida. It was a single referral. And then Ms. Palmer, in order to get those records sent to her treating physicians in Florida, has to sign an authorization, has to request that those records be sent. She has to make the overt act. Whereas my clients didn't just send the records off. That would be in violation of the.
They're required by law to send the records when she requests, correct?
Yes, Your Honor. Yeah, under 456 in the state of Florida and the counterpart in the state of New York, they have to provide those records to any future treating physician if Ms. Palmer requests it. If they produce those records without her requesting, that would be a violation of those practice acts. I also would like to address the minimum contacts because I think that's important. Because when we look at Venetian Salami, you've got to pass the jurisdictional question, and then you got to look at minimum contacts and whether or not my clients purposely availed themselves to the state of Florida. And I think Dean v. Johns is a great example. In that case, they found there was sufficient minimum contacts, but in Dean v. Johns, you had an Alabama doctor who owned 2 pieces of property in the state of Florida. He was licensed to practice medicine in the state of Florida. He acknowledged that he had seen over 2,000 patients across the border from the state of Florida. So he had significant contacts with our state. My clients, on the other hand, don't have any of those contacts. They don't reside in the state of Florida. They don't own property here. They aren't licensed here. Their treatment of Jennifer Palmer, who's a Florida resident, took place in the state of New York. I don't think it matters that they knew that she was moving to Florida, but they continued to treat her in New York. I think that's a red herring. I don't think it matters that they made a single referral to a Florida physician. We would all expect our doctors to make a referral to an out-of-state physician if we were moving out of state and we.
This seems to come up a lot where people go to out-of-state doctors. I haven't looked at every state's long-arm statute, but there are commonalities among them. I know ours is, heavily modeled after Illinois'. Are there any other long-arm statutes in other states that address this issue?
Your Honor, I'm not aware of any right now. But I would agree that this is a somewhat novel issue in the state of Florida, which is surprising given, the number of citizens we have and the type of issues we're dealing with here.
There are going to be millions of people that go to out-of-state across the country that go to live in one state, go to doctors in another state, and then end up having a medical malpractice claim for whatever reason.
And I think the simple answer for that is typically the medical malpractice claim is brought in the jurisdiction where the medical malpractice happened. And that's not what's being attempted here. What's being attempted here is we've got 2 New York doctors and a New York hospital system that have no relationship with the state of Florida that are being attempted to be hailed in the court here.
Is there a suit in New York as well, or is that not?
There's not a suit in New York. And it is a 2019 case. So it's, this is really where the suit is going to happen, if it's going to happen. Yeah, again, I would point to the Venetian salami test. Yeah, I don't think that we've satisfied the tortious acts. I don't think that they've satisfied the 1A6 with the service activities. To allege service activities, to me, you're having to allege the medical records are essentially the product that's coming across state lines. I don't think that's the case, that those records were created in the state of New York for the state of New York. You know, going to 1A6 with the Thomas v. Romer case, that case is distinguishable. In that case, you have the University of Miami who sent a serum sample to a laboratory in Pennsylvania. That laboratory knew that that was coming from Miami. They then ran their analysis, ran their tests, and sent their report back to Miami. So they knew that the labs were coming from the state and were going back to the state.
Well, but some of the treatment that your clients conducted was after Ms. Palmer moved to Florida, wasn't it?
It was after she moved to Florida, but the treatment only occurred in Florida. And just because she was going
New
back to
York?
Florida,
You mean New York?
going back, she was,
How's that different than Thomas Jefferson? They processed the blood in Pennsylvania for somebody who they knew lived in Florida and was going back to Florida. In this case, they gave medical care to a Florida resident who they knew was going back to Florida.
well, in that analysis, Your Honor, the individual is essentially the product or the service activity. And I don't think that's the intent of the statute. I would argue that it's meant for products liability actions. It's being attempted to relate to this present action, but you don't have an actual product, which, you know, whether that's a tangible item, you don't have a product going back and forth. You have an individual. And I don't think that that's the same as what was found in Thomas Jefferson. So ultimately, I mean, I don't think 1A, 2 has been met. I don't think the tortious acts occurred in the state of Florida. I don't think 1A6 is met. I don't think the service activities occurred in the state of Florida. And then minimum contacts, I think very clearly these clients or my clients always remained in the state of New York. Their treatment was always in New York. The very limited contacts that have been alleged in the Second Amendment complaint still, I don't rise to the level of being beyond fortuitous or random. I think that this court ultimately should find that the contacts weren't necessary and jurisdiction isn't met. And I know I haven't used all my time, but I'm happy to answer any further questions you have. But I'd ask that the court uphold the lower court's ruling.
No, thank you, counsel.
Judge Mize, the tort is completed in Florida when the injury occurs in Florida. That is the tortious act. You can't remove the modifier tortious from the act. And so Judge McPhee, you mentioned something about Georgia, and that's in one of the cases. They talk about an example of someone assaulting someone across the Georgia line. They throw a ball and the ball hits across the line. The injury occurs in Georgia, and they use that exact example.
So
We're
supposed to interpret statutes, not to render any word meaningless.
Yes,
Under your interpretation, what work does the word act do?
the act is the,
Like, how is the statute different for having the word act in there as opposed to just commit a
that's
tort?
the breach. That's the breach. The act is the breach, the duty, the breach that occurs in New York. And then
How is
the
it different?
injury occurs here,
How is that any different than if it just said commit a tort, stop?
committing a tort
Yeah, what
instead of
if
a
it just-
tortious act.
Yeah, what if it just said commit a tort? What
If it
does the
was,
word act add to your interpretation of the statute?
I think you can't just say it's the act, it's a tortious act. I mean, that I can't answer your Honor's question. I know what you're asking and I can't answer it because the phrase is tortious act. And I think Judge Farmer's concurrence discusses what you're saying. It doesn't say commit an act in Florida. But it's,
utilizing the example that you were giving us
Mhm.
about the ball being thrown
Right.
across. The act is the throwing the ball.
correct,
It's not throwing a ball is not tortious at all until
No.
it hits that person.
correct,
So
the
what
injury,
you're- but the action itself is not completed as that ball is in the air. And the
Well-
difference here that I'm seeing is that we're discussing a situation where the act of the doctors in New York concluded.
No,
They were being mandated to give the other reports because under their rules, they have to give it when requested.
right.
But their actually diagnoses of the patient were done, and the patient then came to Florida and continued to get sick.
Their breach occurred in New York. The tortious act completed here in Florida because the injury occurred in Florida. That's the difference. Their act did occur in Florida. The tortious act completed here because the injury occurred here.
I want
No, go ahead, Judge.
to make sure I get an answer to my question before your time expires. I
Okay.
asked you before they.
Oh,
make an
yes.
Argument.
Yes,
Is there any act that, under your interpretation of 1A2, is there any act that would satisfy 1A6 that would not satisfy 1A2?
I haven't come up with one yet. I do understand that there is a tight mesh between the two. And it's important to think about the legislative intent behind the predecessor statute to 48.193 that was enacted in 1971. Florida legislature said that a plaintiff shall have personal jurisdiction over non-residents for wrongful acts committed outside of Florida, which causes injury to persons within Florida. So the statute that we're talking about, we don't have the legislative history on this statute, but its predecessor, 48.182, which is similar in its verbiage, anticipated that the injury would occur here in Florida. So we are well within the legislative history. We are well within the public policy of making the injury occur here in Florida and adopting what Dean did with regard to 1A, 1A2. Your Honor asked questions about negligent phone calls and assistance with from my trial counsel, paragraphs 59, 73, and 79 provide that. This is not, I just want to be clear, this is not just about sending medical records, because that would open a floodgate unless, and Your Honor asked the question, why hasn't this occurred before, right? We have Sloan Kettering, we have MD Anderson, we have specialty cancer places. The professionals, the medical professionals can prevent being sued here in Florida. They can contract away personal jurisdiction. They can say, I will treat you and contact your doctors in Florida. I will collaborate with them as they did here, but I will not be sued in Florida. They knew that Jennifer was coming back and forth between Florida. They knew and they were aware. They called her Florida doctors. They didn't just by law submit the medical records that they're required to do. They went more. They went further. There are sufficient minimum contacts that we have alleged in the complaint, as well as Jennifer's affidavit that mirrors those allegations, that dovetails those allegations. This is not a forum shopping. I appreciate that question. This was not. And so this case, this court should feel good about finding that.
What about Judge McPhee's question in that regard?
Yes.
So if someone does suffer from
Mhm.
some negligent act, right? And then moves again.
Sure.
And then moves again, how are
Right.
we then to tell at what stage does the proper forum become obvious?
Well, lucky for me, that's not the facts here. And these facts or these cases on personal jurisdiction are decided on a case-by-case basis. The facts do matter. So the facts in my case matter, that there was a referral, that there was contact with the Florida doctors. There was purposeful availment of the state of Florida, and they didn't have to do that. They did that. So they injected themselves within Florida by collection processes that are not in any of the other cases.
Any person that treats patient in their home state, a
Mhm.
doctor who's a patient subsequently moves to Florida,
Right.
wouldn't that be telling them don't have phone calls with the patient's new doctors in Florida?
It would tell them they could prevent long-arm personal jurisdiction by contracting in a way. I
Do
know
you think
doctors do
think
that.
legally, or do you think they're gonna read this, hear about this case in the medical news and
Sure, yeah,
say,
I
hey,
do.
if you're gonna have a phone call, if
Yeah.
a patient moves to a new state, you got a phone call.
have them sign a form, have them sign and waive the right to sue you in Florida because the injury occurs here. The tortious act is completed here, and you can't get away from that. That's the statute.
But you said
So-
something very, very important. I thought you
Yes.
said that facts matter.
Yeah, they do.
Isn't the trial court in a better position than we are here to determine those facts as they were presented to that court?
Thank you for the question. And no, I would say this court is absolutely on the same footing. It's a de novo standard of review. And the facts are concrete in this record. You have the Second Amendment complaint. You have the affidavit of my deceased client, Jennifer Palmer. You have the affidavits, which are vague and conclusory. I didn't even get a chance to point out the doctor's affidavits that do not refute my client's affidavit or my allegations to the complaint. So you are in the same footing, de novo review. It's a question of law. When you look at the statute and the Dean case and decide, because the injury occurred here in Florida, whether you're going to allow personal jurisdiction to exist. And we ask respectfully that you do. It is the right decision. Thank you.
Counsel.
Thank you.
Okay, move on to our next case. That case will be taken under advisement. All right, the next case on our docket is 23-3362, John C. Sylvains versus the state of Florida. Appellant's counsel may approach whenever you are ready, but no rush. Counsel, how much time would you like for a rebuttal?
5 minutes will be just fine.
All right, counsel, proceed when you're ready.
Thank you, and may it please the court. Good afternoon, your honors. My name is Eric Cerise, and I represent Mr. John C. Sylvains in this appeal. This court should reverse Mr. John C. Sylvains' judgment and sentence for the reasons stated in our initial and reply briefs. Although for the purpose of oral argument today, I'd like to focus primarily on issue 1, as labeled in the briefs, which is whether the trial court erred in denying the appellant's motion for judgment of acquittal as it relates to count 1, which was the lewd or lascivious molestation charge. And to answer that question, the court must decide whether section 800.045 requires an actual touching to occur in order to sustain a conviction for lewd or lascivious molestation. And the answer to that question is yes. Now, of course,
Counsel, let's say that we accept your premise. Let's say we do that. What is the remedy? Do we go back to the trial court to determine whether an attempt occurred, much like was found in count 2, or what is your proposed remedy?
the remedy is for count 1 to be vacated, for this court to remand this case back to the trial court for further proceedings. Those proceedings would be a corrected score sheet, because the lewd and lascivious molestation charge was the primary offense on Mr. Sylvains' score sheet. And he would be entitled to a resentencing under only the convictions that would remain in place. I'm sure this panel is aware of the fact that we did not challenge count 3 of Mr. Sylvains' trial. That is the lewd or lascivious exhibition charge. We had no good faith basis to challenge that conviction because based on the evidence that the state presented, that count went to the jury, rightfully so. But our briefs challenge the lewd or lascivious molestation charge, which we think needs to be vacated. And we also challenge the attempted sexual battery conviction as well. But as I mentioned, I think the most important question in this case, and really the driving question in this case, is whether.
Counsel, you in looking at the language of the statute, you know, you make you focus on the to so touch language. and if it's entice a person under age 16 to so touch. If entice in the statute was replaced with solicit, would you be making the same argument?
We would be. It's our position that all of the crimes under chapter 800 require an actual sexual touching to occur. Now, I know that would change depending on what subsection that we are focusing on, but let's take the one at issue.
You're saying lewd and lascivious exhibition requires a touching?
Right, so I've overspoke in that sense. Exhibition would not, but any of the ones that,
Lewd and lascivious conduct.
So-
yes,
So why? Here's my points. I mean, some words inherently don't require completion of the act. If you solicit someone to do something and the crime is soliciting, they don't have to complete it. You just have to solicit them to do it.
sure.
And so when it says solicit to so, if it says entice to so touch, question to me there is, I get the emphasis on so touch, but what does the word entice do? And the definition that you quote us in your brief for entice includes to solicit.
Right.
Which solicit kind of inherently involves, typically involves when an act's not completed. It's just the mere solicitation that can go on to be completed. But the prohibited act is completed when the solicitation occurs. So to me, it's not so much this to so touch, it's how does entice act upon the words to so touch? So I guess what I'm saying is how you tell us entice means solicit, that's in your brief.
I think a lot of those words that are used in chapter 800 are interchangeable. And I think there's actually a few answers to your question, Your Honor, as to why even with the language solicits in L&L conduct or entices under subsection 5 still requires a touch to occur.
Why?
Is for a few reasons. First, I know this court is aware that when we're construing statutes, we have to construe them as a consistent whole to try to harmonize them, to try to have some symmetry, so that we're not rendering some portions obsolete or redundant. So when you look at the first portion of subsection 5 under the lewd or lascivious molestation statute, it says that a person who intentionally touches. So I think there's no question that under the first version of L&L
Second, it's
molestation.
entice to touch.
Sure, but it really would be inconsistent for the first portion of that crime to require an actual touching.
Why would it be
And for the second
inconsistent? The two portions use different words. We don't normally expect different words to have the same meaning. Normally, if you use one word, one set of words in one part of a statute and a different set of words in another part of the statute, you're trying to accomplish something different with the different words, not the same thing with different words.
Sure, that's fair. But I think another way to resolve this issue is by looking to the attempt statute itself, 777.04. It's got a really important sentence in the first subsection. So 777.04 says in subsection 1 that criminal attempt includes the act of an adult who, with the intent to commit an offense prohibited by law, allures, seduces, coaxes, or induces a child under the age of 12 to engage in an offense prohibited by law. What the legislature is telling us in this statute is that those particular crimes are attempt. They're separate from the substantive crime of, let's say, lewd and lascivious molestation. What that tells us is that the crimes that are enumerated in section 800.045A contemplate an actual successful enticement or an actual successful sexual touch. Otherwise, this portion of section 777.04 would be rendered completely meaningless. And the
What about
remedy,
subsection 6, which refers explicitly to solicitation of a
Right.
person under 16 to commit a lewd act. You think subsection 6A2 requires an actual touching?
we do. Now, I understand that that might be a bit inconsistent with what was raised in the initial and reply briefs. Initially, we had argued that this particular factual scenario is covered by L&L conduct, and so therefore you have to interpret molestation different than you would conduct. But in light of researching, frankly, for oral argument today and getting ready for this, we've discovered that 77704 makes it clear that crimes that involve luring, seducing, and coaxing and inducing a child are attempt crimes under 77704.
Counsel,
What
is
would
it
that
fair to
mean?
Make a new argument, an oral argument, but the other side didn't get a chance to respond to
No,
the briefing?
I wouldn't necessarily say it's a new argument because the brief absolutely cites to the criminal attempt statute I think really what this does is it clears up any ambiguity in terms of the specific language that the legislature has used to articulate.
You just told me it was inconsistent with what you argued in your briefs.
Well, I'm not necessarily, then I misspoke. I think this really just, again, it clears up the ambiguity with the word choice that the legislature has used. We have,
Counsel, then what do you think the word entice is doing in that statute? What's its function?
it's the method by which the perpetrator accomplishes the touching. Just as forces or entices is the method by which the perpetrator accomplishes the touching.
So are you abandoning your argument that the to-so touch language, are you abandoning that argument?
Not at all, not at
You
all.
made- Because it sounds like you're now going on some sort of an attempt argument, but that attempt wasn't charged in this case.
No, and we think that the facts at best fit an attempt, and that's all that was created here. And we actually filed some supplemental authority on this point.
Which leads to my first question as to the remedy. Could the court not have, pursuant to the Florida Rule of Criminal Procedure 3.620, could the court have found an attempt rather than allowing it to go through on the lewd and lascivious molestation?
No, Your Honor, because the jury wasn't instructed on that. Despite the fact, and this is what my supplemental authority shows, despite the fact that the standard jury instructions for L&M molestation, the crime at issue, includes as a permissive lesser included attempt. And so the facts of this case fit the attempt. They don't fit the completed crime, which is what the specific language of the statute requires. Another way to,
The forces or entices, right? All right, go on.
well, we're still all talking about the same thing, and another way to resolve what the legislature intended for this crime to cover is by looking to other statutes to see the language that was used in other statutes. And obviously, you know, the court is aware of the statutory construction case law that says that when the legislature has included a provision in one statute but omitted it in an analogous statute, courts should not read into it. Courts should not read it into the statute from which it has been excluded. That's the Messon case from the second DCA in 2019. Before I get into the specifics, I also want to point to the Gould case. It's the first DCA case 2022. That case says explicitly, the legislature has filled criminal statutes with examples that demonstrate it knows how to specify when it wants an attempt to be an offense in violation of a provision other than section 77704. A prime example of this is the sexual battery statute, which in a couple of spots criminalizes both sexual battery and an attempt that results in the injury to the sex organs. And then it goes on to say, there are many other examples. And there's actually a footnote in Gould, footnote 7, I urge the court to take a look at because it provides a laundry list of criminal statutes where the legislature explicitly included in the substantive statute attempt to commit X, Y, Z. That's not what we have here.
In reviewing 800.04, okay, the lewd and lascivious chapter.
Sure.
You have the lewd and lascivious molestation for which your client was convicted,
Yes.
which talks about enticing to so act, force or entice to so act. Okay, referring back to the first sentence of a touching.
Correct.
Then you have subsection 6 that talks about a person who, subsection A2, solicits a person under 16 years of age to commit a lewd or lascivious act. So is your argument that frankly, there is a provision and a section of the statute that hits on the very issue that does not address touching? And that would be the lewd and lascivious conduct versus the molestation where it takes conduct and adds a touching element to it. Is that your argument?
Well, I'm not sure I fully understand your question, Judge.
Why would the legislature have two different provisions of the statute? One on molestation, one on conduct. Molestation, I believe your argument is here today, requires a touching. There wasn't a touching in this case. Therefore, there can't be a conviction for touching.
Yes.
For molestation. The state chose not to charge with conduct, which means to solicit a person under 16 to commit a lewd act. The solicitation itself to commit the lewd act is the crime under subsection 6 of 800.04.
So
He wasn't prosecuted under that.
right, so on that point, I would disagree. I think that even under a plain language assessment of L and L conduct, a touching is still required for that crime to be committed.
So how is 5 different than 6 under, because you're now telling us you think they both require touching, which is different than what you said in your brief,
It's true.
right? So how is 5 distinct from 6 then?
Well, it in a variety of ways. 5 differentiates between body parts. 5 differentiates between age ranges and makes punishments different depending on.
They're both for under 16-year-olds.
Well, my understanding is that L and L molestation also goes lower than that. Yeah, I mean, under subsection B, Your Honor, it says an offender 18 years of age or older who commits an L and L molestation against a victim less than.
I know,
12.
we're dealing with 5A. That's what your client was charged. in.
Sure. And I guess the main distinction there would be the difference in body parts. So I think that's
The difference in body parts is the difference between a sexual battery and a little lascivious. That's where your difference in body parts come in your penetration versus touching. You're indicating your argument here today is that little lascivious conduct requires physical contact.
we think so. We think under a fair reading of that statute, it does. If you look to the first portion of the L and L
Are you
conduct.
not undermining your own argument? I mean, that he wasn't convicted of that.
No, he wasn't. He wasn't. He was convicted of L and L molestation, which we think equally requires an actual touching for the crime to be completed. And the best point for that is the legislature's use of attempt language in other statutes. So if you go back to that Gould case, they list a laundry list of criminal statutes that expressly include attempt to commit. And it's in the context of sexual activity crimes and crimes that involve enticement and luring. Section 784.011, sub 2A and B, a person 18 years of age or older who commits sexual battery upon or in an attempt to commit sexual battery injures the sexual organs of, so on and so forth. There's more. We put one in our brief. It's the use of a computer service to solicit sex acts from a child. 847.0135. This is in
So and
subsections 3 and 4.
and that statute's use of solicit, it's just the soliciting. The act doesn't have to be completed, right?
Well, no, but my point is that the language of the statute says seduce, solicit, lure, or entice, or attempt to seduce, solicit, lure, or entice. The legislature specifically using that language in other criminal statutes, the same language that we see here in section 800.04.5, but they don't include the attempt to force or entice. As part of a statutory construction assessment, this court's supposed to look at those statutes and see that the legislature intended to omit one place where they have it in another.
But does that argument hold up if the state's argument is that just enticing would be the completed act? Then do we even need to get to the attempt? Doesn't that argument fall apart if the completed act is the enticement, which is what I think the state's arguing?
Well, sure, but I think our point is that it can't be under a fair reading of the language, which also includes the to so touch language. We have to consider this as a whole, and not only that, we have to harmonize the statutes so as to not render other criminal statutes superfluous or redundant. And if we did that, if we followed the state's interpretation, that would render what's in 77704 completely redundant.
Do you think the use of solicit in all of the sexual crime statutes always requires a touching then or a completion of whatever the act solicited is?
Well,
I think of like solicitation of prostitution, right? Somebody solicits a prostitute to engage in sex acts, but the sex acts don't occur. Are they not guilty of soliciting a prostitute?
well, no, I don't know the answer to that question, Judge. I think it's a fair point. But I think it has to be balanced with 7704, where they're telling us, the legislature is telling us that criminal attempt
Yeah,
includes.
but the point is, some acts on their own, the solicitation is itself an act. And
Sure.
So in some cases, the legislature chooses to criminalize an act. And in some cases, it chooses to separately criminalize just a solicitation of someone else to commit an act,
Sure.
right?
And I think under that specific example where we're talking about maybe soliciting prostitution, that would be able to be analyzed that way without cutting against what my argument is for 800.04. Under the plain language of 800.04, it requires an actual touching, and the forces or
You
entices is
keep
the
saying
method
that,
by
but it
which.
kind of just like, we don't get to the underlying why. What the plain language requires depends on what the word entice means,
Sure,
right? So to say the plain language requires it, we got to go deeper than that.
sure.
But the word entice is the key word here.
Yes, and
Is
I,
entice akin to solicit, which I know in obviously in many contexts is, and obviously you would use solicit often at times when you're requesting someone else to do something, right?
Right.
Like, it kind of makes sense to criminalize battery and attempted battery. It really doesn't make sense to criminalize making a request and attempting to make a request, right? Because there's not really, it's a much more, difficult concept, attempting to make a request, because that's not really something you're likely to attempt and not complete. So there's a reason that you would,
Sure.
in the context of solicitation, not criminalize attempt, but criminalize, basically the solicitation is the attempt, right?
Sure.
It's a situation where the attempt stands on its own as a crime without the next crime being the same thing.
sure, Judge, that makes sense to me.
The question is whether entice is the same.
Well, I think because the legislature has chosen in other criminal statutes to expressly say attempt to solicit or attempt to seduce, or even attempt to, I'm sorry, entice.
In this statute, you have the legislature utilizing an 800.04. In one section, they say force or entice. In another section of the statute, for another crime, they say solicit. Do you not believe that they're intending them to be different?
Hold on, and did you cite us, I'm sorry, I'm gonna give you.
No, no,
questions.
it's fine.
Did you cite us any statute where they said attempt to solicit?
I believe so. I'd have to double check the language, but
I know there was attempt and solicit, but was there a statute where it was attempt to solicit?
yes, yes, and it's in our brief. It's 847.0135 sub 3 and 4, and that relates to the traveling to meet a minor cases. and using a two-way-
8470135?
Yes, yes, Your Honor.
right.
Sub 3 and sub 4.
All right, and I didn't mean to interrupt.
No, it's fine. And unfortunately, Judge, I seem to have forgotten.
Well, we're talking about the word entice and it's like it's being used interchangeably, entice and solicit. The legislature used two specific words, one in 800.04 sub 5s,
Sure.
and the other in 800.04 sub 6. If the legislature intended them to mean the same, they could have very well used the same word, right?
Agreed.
The dictionary has different definitions for entice and solicit, does it not?
It does, although they're often used interchangeably, but I understand from the legislative construction
Well,
standpoint that they've
entice
chosen.
seems to indicate more than the solicit. Solicit, you're asking, enticing, you're giving an increased.
Right,
ask,
there's-
And you're
right.
giving some sort of reward.
Right.
As I understand the language to be. So I guess the question is, why would, if you're saying that touching is required throughout that statute, and the legislature is using different language, and they didn't put the to-so touch in the conduct. You've lost me on this argument that you're making. Frankly, I've never heard this, that throughout that entire statute, touching is required.
No, and I definitely overspoke with that
Because-
right out of the gate because exhibition doesn't require touching, but I still believe that under the plain language of 800.06, or I'm sorry, 04 sub 6, which is L&L conduct, and 800.05, that based on a reading of that statute as a whole, it requires a completed act of a sexual.
All right, Counselor, your time has expired. I'm gonna give you
I
3
see that,
minutes. for
and I
rebuttal
apologize for
because
going over time. Thank you,
We
Judge.
didn't exactly let you get through your presentation.
No, that's understandable.
I'll give opposing counsel the same extra time.
May it please,
Give
excuse
me
me,
1 second.
May it
Just
please
fix the
support-
timer here. Hold
my
on.
name
One
is
moment.
Oh, I'm sorry. All right, I think I've got it. All right, go, counsel.
may it please the court. My name is Stephen Putnam. I represent the state of Florida today. As to issue 1, under a de novo standard of review, the trial court properly denied appellant's motion for a judgment of acquittal. State contends that the plain language reading of the statute is logical and a legal interpretation of 800.04.
Counsel,
From-
if
yes.
entice does what you're suggesting in your answer brief that it does, that enticing, am I correct that you're saying the operative word would be entices, you don't have to have the touch? Number 1, is that true?
Yes.
Okay, next follow-up. How is that different than subsection 6A2? Why would they put both of those in there? If 2 is solicits a person under 16 years of age to commit a lewd and lascivious act, why would that be any different?
I'm sorry, can you repeat like what you're comparing? Are you
Sure,
comparing
the,
lewd and lascivious conduct? Or which one? I'm sorry.
Yeah, the conduct with which he is
So-
charged, so lewd and lascivious molestation under 5. My understanding is that you're saying just ask, I mean, let's just sub in words, right? Which I wouldn't want to do, but we're gonna do it. Entice, asks, trick someone into, right? I hesitate to say solicit because now I'm gonna go right to subsection 6, which says solicits a person to commit a lewd and lascivious act. What would be the difference in your mind between 5, lewd and lascivious molestation, and lewd and lascivious conduct?
So lewd and lascivious conduct, well, let me back up
Yeah.
a second. Lewd and lascivious conduct is actually touching, and there actually are attempts to commit that touching.
Oh, wait, hold
Further-
on.
oh, I'm
Lewd and
sorry.
lascivious molestation is, what's touching?
Lewd and
Conduct.
lascivious conduct.
Okay.
Which is subsection 6.
But we're talking about A2.
Yeah, I'm talking about the
A2
second.
says
A
a
person,
person who solicits a person under 16 years of age to commit a lewd or lascivious act,
yes,
commits lewd or lascivious conduct. So one type of lewd or lascivious conduct is soliciting a person under 16 to commit lewd or lascivious conduct.
that's correct.
Okay, if subsection 5A also criminalizes requesting a person under 16 to commit one of those acts, how is 5A not completely duplicative of 6A2?
Because those are two different, so lewd and lascivious conduct can be, first of all, an innocent touching of any kind. But it's the intent. So like touching a foot or a knee, if there's a lewd and lascivious desire from the perpetrator, that's
Isn't
what
that
makes
true
it
of lewd and
conduct.
lascivious
first.
molestation also? I mean, they're
I'm-
both,
No, I'm sorry, Your Honor,
they're both saying lewd and lascivious.
but there's a difference. Lewd
Okay.
and lascivious molestation actually specifies touching certain parts of the body. Lewd and lascivious conduct is more general. So it could be used, for instance, touching feet I didn't cite that case, but there is a case like that. So that is basically the difference. The molestation is getting a sexual pleasure from touching certain parts of the body or having certain parts of your body touched versus conduct where it could be interpreted innocently. And I want to make just one more point about the difference also. That's a charging decision. So as a prosecutor, you get to decide what fits the facts better. And that's to help your case when you go to trial to meet those elements in a million different circumstances. So it would just depend on the facts. And in these set of facts, the prosecutor saw that the victim was told to get on her knees after being locked in a room or close the door and being private from the others and taking his pants down and exposing his penis.
So what do you think to so touch is doing in the sentence?
To
After
so
lewd
touch
lascivious
is the
molestation.
goal. So the verb entice, which it is a verb, is, so just to go back to it, to make it make sense, to entice someone entice is a verb. The goal is to have them touch you. And in
What
some of the,
about
oh, I'm
forces,
sorry, Your
though?
Honor.
I mean, if we're looking at this portion of the statute and it says forces or entices, it seems to me that forces to touch is not just. I mean, that would presume the completed act of the touch, because I
could
force you to
explain.
touch. Okay,
So let me just finish up with so in the lewd and lascivious molestation. So the first part of it talks about me as the defendant doing the touching. Now, the other section where it says or forces or entices is I'm getting the victim to actually touch me,
Doesn't that
whether
help
through
them?
force, whether through enticement, but it's to touch my private organs or areas.
okay.
But within
But you
that
said,
statute itself.
no,
Oh,
go
I'm
ahead,
sorry.
Judge McCarthy. I
Within
think we're
that
gonna,
statute, they're talking, the first sentence is you utilize the example, you doing the touching being key.
Yes,
If you're just thinking about it and you don't touch, there
Correct.
is no crime
correct.
under this provision. The next sentence then says, or forces or entices to so touch. Again, it seems to be indicating the completion of the actual physical touching. And why in that statute is that not the same? Because otherwise you'd be in subsection 6.
I think when it comes to the whole statute in general, whenever I don't intend to understand why the legislature wrote the way they did, but
You just use their words, right?
yes, and the plain reading of the statute is you're enticing someone to complete an act. Entice is a verb. Again, it is to have someone to solicit or to entice in some way. Like, and I tried to think of many different analogies of an attempted enticement, but you can't attempt an enticement. And I believe Your Honor made that point earlier. So does that answer your question? I'm sorry.
Well, I mean, when I look, under Merriam-Webster, entice. to
Maybe
attract-
just have some water real quick.
To attract artfully or adroitly or by arousing hope or desire. What action was done to entice rather than what solicit is, to approach someone with a request or a plea? Solicitation seems to be there under subsection 6. You just said it's a prosecutor's decision.
Mhm.
The record seemed to reflect that the probable cause for the arrest was for an exhibition. The prosecutor chose to take on the higher burden of something different.
Exactly.
But the touching seems to be very specific, needs to actually occur.
I think that, and how I read it, and again, just reading the statute on its face, it clearly says you either have to, I'm going to use myself as a defendant again, have to touch the person in those body parts, or B, I have to have them try, I need to attempt to try. And I think entice and attempt are interchangeably inside of that subsection, because the goal is to have them touch you.
But
That's the goal.
But there's statute.
But I'm sorry, Your
There's
Honor.
statute that could put the word attempt in. there.
And again,
Right.
that's the other thing I'd like to say is, yeah, the legislature could have just cut it off. They didn't, why did they need to put enticement or force? They could have just said touch, or they could have actually said to actually touch, or they could have put forced or enticed to so touch actually, but they didn't. They put it in because the way they, at least from my understanding, this is a part of a set of crimes that has a core of evil. I think I was reading in one case, and that they wanted to look at all cases and all scenarios that could possibly be interpreted. And not all cases involve the defendant going and touching someone in an inappropriate area. There's cases where people invite children into vans, like the old stereotype that we've seen in movies, with candy or puppies, what have you.
But what charge is that?
But see, that would be a different charge. That wouldn't be molestation.
Well, how is that different than what happened in this case when there's no completed act, right?
Mhm.
Why is it distinguishable?
It's distinguishable, A, because you are trying to entice a child or person to touch certain parts of your body that aren't exposed to the world.
So then in your mind, it's true that lewd and lascivious molestation could always be lewd and lascivious conduct, but under six, I had it before when I asked you, 6A2, but 6A2, lewd and lascivious conduct might not always be lewd and lascivious molestation.
Correct. Can I give a couple examples, if I may?
If you'd like.
Again, like lewd and lascivious conduct is an innocent touching that could be interpreted indecent because of the intent of the person.
Isn't that sexual battery?
That's different. Sexual battery is having union with an orifice.
Why are there so many cases talking about double jeopardy in the context of sexual battery and lewd and lascivious molestation if lewd and lascivious molestation doesn't require a touch?
So sexual battery and lewd and lascivious molestation, part of lewd and lascivious molestation is that first part, the intentional touching. So that is analogous to sexual battery or attempted sexual battery. Basically, there is some contact between the victim and the defendant, where in that subsection, it says, or forces or entices to do so. That's different. And I'll be honest, I looked at every case I could. None of them are on point about enticement. They all the cases indicate that sexual battery or attempted sexual battery and lewd and lascivious molestation with the intent to commit that sexual battery are always charged together, or lewd and lascivious molestation with the touching, that part. But I was unable to find anything clearly that indicates that subsection of forces or entices or forces the touching. So I thought it would have been decided by now. This statute's been on the books for a very long time.
Do you have any case law that supports your they've raised, your opposing counsel has raised several cases that I don't necessarily know hold expressly, right? I see it in there where they're referencing the touching, and I'll grant them that. But this explicit holding maybe that we would have to do if we reversed on this case. But what I want to ask you is, do you have anything that helps you in this regard? If they don't have the home run case, they have Kate, and maybe he wants to now approach this on rebuttal, but if it just talks about the touching in the context of this statute, but there's no like home run holding, what do you have in the case law?
So in preparing for this, so I'll be honest,
Yeah.
you do appellate law,
Okay.
but I've been a prosecutor for 10 years. I
Welcome.
did find not a new case, I'm sorry. I did find a case that alludes to it. And I didn't put that in my brief because I'm not gonna put a case in the brief that just simply alludes to facts. But if you would like me to supplement, I can, but in that case, briefly, the short version is it doesn't state any facts. It just says you either do it or you don't do it.
Do what? Touch?
Lewd and lascivious molestation. That's all it really.
Okay, so there's no case in Florida that you can identify that interprets the lascivious molestation in the manner in which you would like us to interpret it. Is that fair?
That is fair to say, and I would say in the general context of all cases that I've personally seen and or reviewed for this oral argument, I wasn't able to find anything specifically referring to an enticement and an attempt because that just is not a thing. And you can attempt to do a lewd and lascivious molestation of the touching kind as specified in the first paragraph.
What about how entice is next to this word force? Because while maybe we could sit here and pontificate and say, well, entice could be attempt, maybe they mean that, but what are we to do with force? Because if force is next to entice, force, I would think sort of presupposes the completed act because you're forcing them to do the thing. If you haven't forced them to do the thing, you haven't completed the thing, don't we have to complete the thing with entice?
And force
So,
and entice both modify to so touch, right?
Right.
So force requires a completed act, that would indicate entice does too.
Yes, so I'm sorry, can you repeat that just briefly, just the point you wanted? I'm sorry.
I'm sorry.
That's okay. All right, I'm troubled by the fact that force and touch are right there. They're after the same disjunction.
Oh, I see what you're saying. Yes.
So if you were to
Now-
say, and Judge Mines is right, they're modifying the same to so touch. So we're going to now modify how we to so touch.
Yes.
We're gonna do it by forcing. Whereas entice could maybe have, I don't know, we're saying everyone's taking for granted that could be attempt, right? Could force, I would think presupposes the completed act. You force
Yes, you
them
could-
to do. So why are those two things right next to each other and modifying the same prepositional phrase?
Because I'm going to use an example. So enticement is a positive way to get someone to do something. Force is, I have a gun. You're going to do X, Y, and Z to my body.
But two ways to accomplish what goal, right?
And the goal
Force and
is-
entice both modify to so touch,
Mhm.
and force really requires a completed act, right? To
No.
make sense.
No, you can force someone without touching them. Again, the analogy with the gun.
If you force someone to touch you.
Yeah.
I don't think you've successfully forced them to touch you unless they touch you.
No, you still have,
You've attempted.
but again, now you're using attempt and not, so that whole
Well, that's my
subsection.
point. They don't say attempt to force, they just say force.
Force. So you
So in
can,
the context of force someone to touch, that implies a completed touch. And force and entice both refer to so touch in this instance. So that if one refers to a completed act, it would make sense that the other one does.
I will respectfully disagree. I think that both of them are kind of inchoate crimes in regarding like you're attempting to, so again, I use the examples of force and entice. Forcing someone to do something to you, enticing someone to do something to you. You don't have to touch them to have that action. I'm going to tell your mom, if you don't touch my penis, that you skip school. That's a form of force.
But here's my point, if they don't actually complete, if the victim doesn't complete the touching, have you forced them? to
Yes.
Touching?
I've forced,
I'll be honest, Council, that sounds ridiculous.
Didn't you just try to get them to force? Or
No,
didn't you try
that's,
to force them to touch you?
I think that's semantics a little because I am attempting.
That was semantic?
No, I mean, like the wording of force and entice are kind of interchangeable just in regards to,
So that makes my point, counsel, about, well, if we take force and if, as Judge Mize put it, if you force someone to touch you, didn't you necessarily complete that act? You got them to touch you, otherwise you didn't actually force them to touch you. But if those are interchangeable, wouldn't enticing be doing, and I don't think they are interchangeable, but I think that they're modifying the same thing. I think that they are words that are next to each other. I'm to do something with that from a statutory construction standpoint.
Can I respond? And
Yeah.
I still think that the first part talks about intentional touching. That's the person committing the act.
Right.
The second part simply says, I'm forcing or enticing the person to touch me. Does it have to be completed? I don't believe it has to be completed because you can force something like, for instance, again, the scenario, I'm going to tell your mom or I'm going to hold a gun to you if you don't touch me. The person could run out, just like in this case.
And you think somebody would say, describing that situation, he forced her to touch him when the
Yes.
touching never occurred.
Because she ran out, she stopped it. So that would be
So you-
exactly
you
what
think when
happened
they
here.
describe that to somebody, they would say, he forced me to touch him. And the person would understand from that, that touching did not actually occur. That's your argument.
That is
So you-
my
so you think the
interpretation
English-
of
that's- so you
forcing.
think the English language is used?
That is my interpretation.
And-
Because you can force someone without completion. You can
How?
force someone to possibly do something.
Can
Now,
you-
if they do it, they don't.
Well, distinguish that from attempt someone to force.
I'm sorry?
Distinguish what you just described, that's forcing, when the
Mhm.
forcing is not successfully completed and the touching doesn't occur. How would that be different than attempting to force somebody to do something?
But attempting, there is no, at least I'm unaware of any charge of attempted force.
I'm just talking about the use of language and how the word force is used, right? If I force, attempt to force someone to touch another person and I don't succeed, I think any normal person would say, he attempted to force him to do something. He didn't successfully force him to do something.
Again, I think it's the same as I stated that you can force someone to do something. If they do it, they do it. If they don't, they don't. Just like I can entice someone to do
So
something.
you force someone to do something, whether or not the thing ever occurs, you force them to do it.
Yes, because I force them to get on their knees, for instance, or I force them to.
Okay, so you force someone to get on their knees, they say no and walk away, and they never get on their knees.
Yes, Your Honor.
Do you think people would describe, any user of the English language would describe that as you having forced them to get on their knees?
I believe so, at least I would. I mean, in the context of this whole statute, the way it's written, yes, because an intentional touching is at the beginning. And again, an attempted or enticement of that touch or force or enticement of that touching is at the end to get them to touch you.
What are we to do with 77704 attempts, solicitation and conspiracy? What are we to do with that in light of your argument about what lewd and lascivious molestation means?
So when it comes to attempt. Attempt is the completion of a crime, for instance, and it's an attempt to complete an action or complete some sort of criminal conduct. So like attempting lewd and lascivious conduct, for instance, would be a good example, I think. So an attempt to commit a lewd and lascivious conduct would be, for instance, going online, police do these stings all the time, and trying to get the person to come over to have that contact. Whether that contact is of a personal area or not, that's not really the case. My point is that there is a contact to be had and a final end goal
Sure,
in
isn't-
having that desire reached.
Isn't that the solicitation? You're saying it's attempt. The statute specifically calls that solicitation. That is lewd and lascivious conduct. It's not attempted lewd and lascivious. If you solicit, it in fact is the completed crime.
But there also is, there are people charged with attempted lewd and lascivious conduct for that as well. So in like,
For attempting to solicit it,
yes.
so they didn't actually solicit it. They attempted to solicit.
Well, they attempted to have the conduct.
But don't you agree that the legislature has broken this statute down? Now, you used some phrase that you looked at in your research. They've broken this down by the various levels of activity with minors that they're trying to distinguish and say, we don't want you having any of these type of conduct with children, whether it be a battery, whether it be a molestation, whether it be an exhibition, or whether it be conduct.
Yes.
They've broken that down. They've included the language. How do you molest something without there being a touching of that thing, whether it be property in a criminal mischief type action or a child in an action such as this? So
Since
that's the
such a-
language they
Oh, I'm
use, is
sorry.
molestation under this section.
Yes, Your Honor, and I think that the legislature from the whole statute as a whole was, look, we're trying to find every single possibility to protect children in this country or in this state. So my point is, when it comes to that, they broke it down, but yes, they left that part of molestation because it's up to the state to decide how to charge it. If a man just walks around naked, for instance, and I believe actually there's a case cited where it refers to 800 and a man walks to the door naked and the Girl Scouts there or whatever's there. He comes back in the home and comes out naked again. He was charged under this subsection. So
Charged under molestation and affirmed on appeal.
from let me pull it up, but I believe so.
That's
It was,
exhibition. And the question in that case is whether it was indecent exposure or lewd act.
I'm pulling it up. Let me just have a moment. Oh, here it is. Yeah, it just says under 0.04, 800.04, and it was from 84, so it really didn't specify all the different levels of types of
Before you
molestation.
run out, Tom, did you stand by your argument in your initial brief that the appellant's argument as to issue 1 was not preserved?
Actually, we're gonna move on from that and the state will agree it was preserved.
Yeah, I mean, it seems to me when you wrote the initial brief that you ignored the renewed motion for acquittal, where they really specifically argue the specific argument on appeal, which I get, everybody makes mistakes. It seems like you just, from the answer of Jesus, it seems like you just completely missed it. But what I guess was when I see the reply brief pointing out that something in your answer brief was just patently false, I would expect maybe a response or an amendment or some kind of concession of the issue.
Again, whenever I didn't know that we could do that, to be honest, that to reply to his reply brief.
Well, I wouldn't expect another brief, but I
Oh.
might expect some kind of notice of correction or
Well,
request to amend because.
you're asking why that was in there. And I can explain briefly that usually, at least in my time in practice, some judges have said, hey, you've had one bite at the apple, you're done. You didn't present any new evidence after JOA, so you're done. But I agree and will concede that preservation has happened because usually JOA happens after the state closes their case. Then usually the state, the defense then presents some sort of evidence and renews because there's new evidence to consider. So I'm just explaining that in.
So you thought when you were writing your brief that a motion for judgment of acquittal made after the defense arrest without putting on evidence can't make new arguments?
Yeah, and I couldn't find any case law either way going back and forth. But my opinion, and again, I concede to it that it is preserved, but that it's getting a second bite at the apple. And I think that's something that trial judges, depending on the courtroom, determine.
Counsel, I know that you're out of time, but I don't want to let you leave without my understanding your argument perfectly about the word entice. Do you think that the act is completed when someone entices, or do you think entice encompasses attempt?
I think the enticement is the completion.
Okay.
So whenever you have done something to entice, for instance, in this case, expose yourself and have a child get on her knees, that's an enticement to commit an act on yourself. Like a lewd and lascivious molestation, which is touching those body parts as mentioned.
Any further questions?
No, thank you.
Nope.
Can I make just one more statement? And that's it, just that we rely on our brief and thank you for your time.
Thank you.
Thank you.
All right, counsel, got 3 minutes.
May it please the court, 3 points on rebuttal. First, I want to address the discussion that this court had with opposing counsel about forces and entices and how the court's supposed to deal with that. In the Messon case, the court points to a statutory instruction canon called Nociter Associus. It's the associated words canon, which dictates that words grouped in a list should be given related meanings. When someone forces someone to eat a cookie, they ate the cookie. I think that entices should be given a related meaning, in that it has to have accomplished the touching. The second point on rebuttal is the state has argued that the legislature has not written anything in the laws that suggest you can attempt to entice. To the contrary, another statute that I'd like the court to be aware of, and this is cited in footnote 7 of the Gould case, is the 787.025. The statute's titled luring or enticing a child. Subsection 2A says, a person 18 years of age or older who intentionally lures or entices or attempts to lure or entice a child under the age of 12 into a structure, dwelling, so forth and so on, has committed a first-degree felony. The legislature has chosen in other statutes to say attempt to entice, attempt to solicit. They chose specifically not to in section 804 sub 5. The last point I'd make is that in light of this discussion, it's our position that the plain language of subsection 800.045 requires an actual touching just under its plain words and meanings. But to the extent that there's any ambiguity, I'm sure this court is aware that the rule of lenity applies and that it should be construed in favor of the accused. And with that, we'd ask the court to reverse. The last point I'd like to make, being that I do have 1 minute left, is on the remedy judge. At page 192 and 193 of the transcript, the parties waived any lesser includeds, which means that the jury was only instructed on the completed crime of L&L molestation. The fact that the evidence does not support that, and the fact that there are no lessers that were actually instructed, that the jury was actually instructed on, under the Vroom case and under the Morris case that's cited in our briefs, the appropriate remedy is to vacate count 1 and remand with a corrected score sheet where count 1 is no longer at play. And Mr. Sylvain's be entitled to a resentencing with that corrected score sheet. So with that, we'd ask the court to reverse count 1 of Mr. Sylvain's convictions. We'd also ask the court to reverse count 2 under the arguments raised in our initial reply briefs. Thank you, Your Honors.
All right, the court will be in recess.
All right.